ordinance or draft a revision to an existing ordinance to require members of the town board to be physically present during regular meetings and special meetings of the town board and at the meetings of committees that are comprised in whole or part of the members of the town board in the room in which the meeting is being held in order to be counted when a determination is made regarding the presence of a quorum and allowed to participate in discussion and allowed to vote, and to prohibit members of the town board from participating in closed meetings of the town board in any manner, including listening and or observing, unless they are physically present in the room in which the meeting is being held. Attorney Macy did draft a ordinance 2 sub 3 sub 6 sub A. Our town ordinance that exists right now with regards to rule changes is rather ambiguous. And Attorney Macy, perhaps you've had a little bit of more opportunity to review and give us your opinion on whether or not we can move forward on this evening, or is this something that needs to be held over for a meeting?
Well, thank you, Mr. Chairman. 2-3-18 says, and I'll read it, it's very short, amendments of rules. The rules of this chapter, and I want to stop for a minute, it says the rules of this chapter, shall not be rescinded or amended unless the proposed ordinance amendment or motion to rescind has laid over for a regular meeting, and then it shall require a vote of 2/3 of the members of the board. Now, it's interesting to note, I'll take a step back now, it's interesting to note in that section that it doesn't explain exactly what the rules of the chapter are. It doesn't say all provisions of this chapter or this entire chapter, it says the rules of this chapter. Then section 2-3-19 is suspension of rules. That one is much more specific. It says any of the provisions of section 2-3-13 through 2-3-16 inclusive of this code may be suspended temporarily by a majority of the board members present at any meeting. Hindsight's always 20/20. It's always fun that you didn't write it so you can criticize the person who wrote it, because I don't know exactly what it means, and I don't mean it as a criticism of the drafters. They do the best they can at the time. 2-3-19 says these are the rules, suspension of rules, and then it clarifies. So you could interpret that if you're only dealing with 2-3-13 through 2-3-16, those are the only rules that you have to, if you're going to amend, lay over to the next meeting. Understand what I mean? But it didn't say that, so you could interpret it that you're supposed to analyze everything in this chapter, decide if it's a rule, and if it's a rule, then you have to lay it over one meeting and have a supermajority vote. And that's really an interpretation. I can't, that the safer way is to accept this and lay it over to the next meeting and get a 2/3 vote. That's the safer way to do it. Or rewrite these sections at the same time and clarify them so we know exactly, what they mean.
Is a rule, would a rule carry the same definition as an ordinance or a code?
Generally not, no. The code and ordinances are usually synonymous because a code is a culmination of your ordinances. Everything is an ordinance. Everything is a document that's adopted as an ordinance, and then it's inserted into the code. Some communities don't have codes, they just have a book of ordinances. Okay? There's no law you have to have a code book. There is law that you have to have ordinances, and to amend the code book or an ordinance, you have to have an ordinance. Generally, to answer your question, no. Rules, ordinances and codes are one thing, and resolutions are the next level, and motions are the next level, and there is no such thing as rules, okay? You have ordinances, you have resolutions, and you have motions, okay? This speaks to rules, but it says rules of this chapter. So it's something that was anticipated in this chapter that could not be changed without the supermajority vote and one laying over to the next meeting. So I go back to, you have to read everything in the chapter and decide whether it's a rule, and if it's a rule, then this provision, this requirement needs to be followed.
Mr. Fisher?
Yeah, my comfort level on this would be to take the safe and slow route. Understand our Some ordinances are imperfect at best. That's a reality. I prefer the language that's in the agenda, which is language I provided, which is actually to give directive to the town attorney to prepare the new ordinance or ordinance revision. Appreciate the fact that we've already got something before us to consider, but I would prefer to make the motion as it is stated in the agenda under item 6K, which is a directive to the town attorney to do that, and then take this up for formal consideration at our next meeting. So that said, I would move item 6K. I can reread that in its entirety, but I don't know that that's necessary. It's there in detail, that's verbatim what I asked for, so my motion would be to proceed and approve item 6K as it is published in the agenda.
I will second that for discussion. Are you saying that you want the attorney to draft something other than this?
No, I'm not saying that. If that is what he has drafted for our consideration, and he's already that far, that's fine with me. In fact, I've read it, I think it is exactly what I have in mind. I just don't think procedurally we can act on it tonight.
Okay.
But I don't have, I mean, it's appropriate even to mention that. It captures just exactly what I believe we should do. And the other issue I mentioned, and I invoked this at a previous meeting, that section 2-3-12 under notice says ordinances will be placed on the agenda for board action only if they are submitted to the town clerk in written form a minimum of 2 days prior to the meeting in which the action is requested. And I have two issues. I don't know whether this was presented to the clerk 2 days prior to the meeting. I don't think it was, as an ordinance, really out in front of people, and our agenda is not written in terms of acting upon this ordinance. It's just to give a directive to the town attorney. So that's my comfort level or discomfort level.
So would your motion then, would you amend your motion to lay it over to the next meeting? As 2-3-19, I believe says, lay over to the next meeting?
No, my motion is to direct the town attorney to prepare and so forth exactly as is published in the agenda.
Other than this?
Yes.
Okay. You lost me. If we're looking for an ordinance that covers those things, this is it, unless you want something else in here. But we should lay this over to the next meeting.
My point of view is, as our agenda is written, I don't think it even allows us to consider the ordinance revision. It is a directive. The way it's written, it's a directive to the town attorney to do something. To the extent that Mr. Macy's got his homework done already and he can go out to recess, that's great. But that's my point of view, that I don't think we can go beyond the directive to have him do it. Do I like what in fact is before us? Absolutely, and I'll support that, but I can't do it tonight procedurally.
Fair enough. Anything further?
I'll second that.
I think I did.
I'm sorry, did you?
Yeah, you did third.
No, I apologize, I missed that. So, really, if we wanted to take the slow and steady and be cautious, we would be passing this as a motion, and perhaps even, if there are no changes, lay over what's here at the next meeting, and then take it up at the one after that.
Agreed.
That's a possibility.
Okay.
It hasn't been here for 2 days. It was just here to have some discussion, so the motion is fine. I think the question you're asking, though, is whether you're gonna wait 2 more meetings or 1 more meeting to adopt it.
I think
That's really the question. The motion, as stated, would lead you to be going to 2, unless you decide it's not a rule. But I think this is a rule, so it would be 2 meetings. You do have 2, is it my understanding, you have 2 regular meetings a month, one is not considered special. So it would be a month from now where you might be able to act on it, the meeting after the planning commission meeting, or that meeting, is where you would take it up, have further discussion, lay it on the table, and then bring it back for final action in a month. Just so, I think that's what we're talking about here, is I certainly do, per the prior conversation, anybody has issues with it, tell the clerk. We're not on a walking quorum, you're not gonna make any decisions, but so when we get back here, we can continue to refine it, and she could even put, so-and-so had a comment on this sentence, and so-and-so had a comment on this sentence, and put it in the next packet, you know, so that we gather up. That's not, you're not talking to each other, you're not, you know, everything's gonna be at 2 more meetings, so we're not gonna have a problem, but if you wanna get it done, I'm trying to set up good habits, good practices that are legal.
Okay, so then you will be doing nothing more on this until next meeting? After next meeting?
Unless called by one of yourselves or the clerk, but no, I will be doing nothing more.
Anything further? All in favor?
Aye.
Opposed?